Good evening, everybody. I'm Chaz Calenda, and this is episode 2 of Chaz Calenda, Attorney at Law. Tonight, we're going to tackle some of the sticky issues that people may find themselves in when we get involved with driving under the influence cases. And it's going to be one of amongst many topics that we talk about here on this show. I appreciate the coalition for having me back on. Tonight, as I mentioned, we're going to talk a little bit about something that a lot of people that maybe are not familiar with the criminal justice system will come in contact with at some point in their lives, and that is driving under the influence charges. And those are situations where, although we do not condone driving under the influence, it is best to know what you will be facing if that should happen to you one night when you don't have don't have a good night, or perhaps you had a couple too many drinks coming home from dinner. Helping me in this explanation and guiding you through the legal hurdles that you will find yourself in is attorney Lauren Iannelli, my partner over here at the attorney at Inman and Torgy. We work together. We've been working together for the last decade or so in one capacity or another. Lauren, welcome to the show.
Thanks for having me.
Glad to have you on. And one of the reasons I picked Lauren, in addition to her tremendous legal skills, is that Lauren, while she worked with me over at the Office of the Attorney General, became quite immersed in the area of DUI law and became one of the attorneys who would actually be teaching law enforcement how to prosecute DUI cases. And now is in the world of criminal defense along with me at Inman and Torgy, focusing mostly on DUI defense and other criminal defense laws. So, Lauren, why don't you give us a little background about where you've come from, what your background is, and what you're doing today?
All right, thank you, Chaz. So my career started following you around the Attorney General's office as your intern in 2009, and we still work together today. So I worked at the Attorney General's office, as Chaz mentioned, for about 6 years. I did a lot of DUI prosecution. I've done DUI jury trials in Superior Court, countless bench trials, handled refusals at the traffic tribunal, and now I focus a lot of my practice on DUI defense. So, we've really have, between Chaz and myself, we really have a lot of experience with these types of cases.
Yeah, and in the cases themselves, people think of them as pretty pedestrian. They're kind of, they're pretty common type of charges. But in reality, as a practicing attorney, and I'm sure you can speak to this, is that DUI cases are quite technical and in some ways may be harder on the attorney to try than perhaps even homicide cases, simply because of their technical nature and the different types of ways that these cases come through the system. Would you agree with that?
I would, and it's really the one case. I mean, I would never advise anyone to represent themselves for anything, except maybe a traffic ticket. Even then, it's always good to talk to an attorney. But this is especially the one type of charge that, if someone gets it and they have no experience with the criminal justice system, they think, I'll just go in, I'm guilty. I'll just figure out, what's going to happen when I get to court. It's not the type of case to do that on, because they are very technical. The officers are all trained to comply with the same protocol. They're statutorily, there are certain things that they have to prove, and they are very technical cases. So the first thing we do when we get police reports is we look to make sure that the officers complied with the National Traffic Highway Safety Administration procedures and protocols, and that they've complied with the law as well. And there's a lot to it.
Would you say that this is one of the topics in our practice that you think that we get the most questions about from clients, particularly what's going to happen? Am I going to lose my license? How much am I going to pay? Am I going to get a criminal conviction? Would you say this is probably one of the top topics that we get as far as question-wise from clients?
Definitely. And I think that's because the people who generally get a DUI are people who have no experience with the court system. So they're, it can happen to anyone. I say that to my clients all the time. Don't beat yourself up over it too much, because it can happen to anyone. And I've seen it happen to a lot of different types of people from all walks of earth. You know, it just, you have an extra glass of wine with dinner and you get pulled over and all of a sudden you're charged with a DUI and you're in a world that you never thought you'd be in. And that's why it's so important to have an experienced attorney.
Right, and that's why we're doing this series here on Chaz Calenda, Attorney at Law, is we're helping people navigate their way through such situations which they otherwise would probably not know how to navigate their way through. And to have people like you and myself giving people some, pretty casual advice. And again, we're not giving you any legal advice here. This doesn't create any lawyer-client relationship just because we're talking to you here through the coalition. But it's always good to have people giving you some kind of guidance on how to get through the situations. And I would agree with you that this is one of those situations that you're not typically seeing career criminals going through. You're seeing regular people, unfortunately, getting caught up in a bad night or a bad day in a bad situation, who end up in a world of at least financial hurt and perhaps even longer different types of hurt when they come in contact with the criminal justice system this way.
Correct. And I think really the place to start is just educating people on, what to do when you get pulled over and what not to do. So if you want, we can start there.
Yeah, so let's walk through that.
Generally you're getting pulled over for a lane roadway violation. So you can't maintain travel in your own lane, or you're drifting into another lane and correcting yourself and traveling back into another lane. That's an indicator for police departments to kind of want to pull you over or see what's going on or continue to follow you and see what your behavior is on the road. You could get pulled over for speeding. You could get pulled over for something that really, like a tail light or something that really has nothing to do with your driving. There are people who get in car accidents. It's not necessarily their fault. Someone else hits them, and then the police respond for the accident, and they make some observations of you, and all of a sudden you're charged with the DUI. So that's kind of how these things start. Either there's a car accident that the police respond to, someone's calling in to E911 saying that this person's all over the road or traveling, going in the wrong direction on the road or something to that nature. And that's when the pullover happens. Then from there, you've got.
Yeah, one of the things that we talked about last week on here, I know that you weren't on, but one of the things Pat had asked me is what does it take for a police officer to pull you over? What's the standard?
I mean, really, they can pull you over for anything that if they see something, they see your registration sticker is not in the right spot on your license plate. I mean, there's some type of traffic infraction, littering. I mean, really, any type of traffic infraction, they can pull you over.
So at that point, you're on the side of the road. You're it could be day or night. Police officers going to come to your car at some point. What can our clients or people of Rhode Island expect at that point when they're sitting in the car and they have a police officer approaching them after being pulled over?
I mean, in some situations, you have police officers who, based on your driving or in their observations of your driving, they're walking up to the car, assuming they're going to find someone under the influence of alcohol in the driver's seat. Sometimes they just come upon the scene of an accident, not expecting to find someone under the influence of alcohol. So it really depends. There are certain officers, they put extra police officers on the road, maybe on the weekends on a Friday or Saturday night, doing like a blue riptide detail, which is, just putting more law enforcement out to look for drunk driving. But when they come up to your car, I mean, they're going to make observations of you. They're going to look at your eyes to see if they're bloodshot and watery and red. They're going to see if they can smell the odor of alcohol emanating from your car, emanating from your breath when you speak. They're going to be looking at how your speech is. Is it mumbled? Is it slurred? When they ask you to get your license and registration, are you fumbling with your wallet trying to get your license out? Are you fumbling through your documents in the glove compartment trying to get your registration out? Those are all things that they're looking for to make a determination of whether or not they believe you're under the influence of alcohol. So there's not much you can do. I mean, get your documents out as efficiently as you can. They're going to make observations of you, physical observations of you that you can't control.
And they're looking for things like you said, and the physical observations are going to be things like, can they smell alcohol on your breath? So, one of the things that I like to tell my clients is, say as little as possible while you're up there. You want to be cooperative, but you don't want to be, reciting your entire night's worth of events to this officer, because if you have been drinking, the officer is most likely going to be finding that he can smell the alcohol on your breath. It's particularly from the perspective of when you were a prosecutor, when we were both prosecutors. One of the things we're looking for is one of the first things we're looking for in that police report is what were the officer's initial observations of you when they approached your vehicle, or when they first approached you, maybe standing next to your vehicle. And these are the types of things that they're going to see.
Yeah, it's the trifecta. We generally see them in all of the police reports. It's eyes, odor of alcohol, and slurred speech. I mean, those are the big things that they're looking for when they're speaking to you. And if you are under the influence, they're going to be difficult things to avoid them observing. But you can limit the other evidence that you're giving the police officers on scene.
Right, and that's one of the things as a criminal defense attorney, we're kind of trained to try to help our clients avoid, is to try to help, stop. Don't help the police make their case if you are in a situation where you're going to potentially be charged with a criminal offense like this. So don't give them more than what they're asking for. You have to give them your ID, you got to give them your registration, your insurance, your proof of insurance. But other than that, it's basically just, you're following directions to a certain point, and keep your mouth shut. I would say is probably your best bet. What would you think?
And the biggest thing I see is every client I have, I ask them, did the police ask if you were drinking tonight? And what did you say? Because I know that they're going to ask that question. And it's always my clients are always, oh, no, I didn't say anything, or I told them I had one or two. Then I get the police report, and it's like, not only did you tell them how many drinks you had, you basically gave them a cocktail recipe. Like, oh, well, I had 3 Jack and Cokes. I filled a 12-ounce glass with ice. I filled it 3/4 of the way with Jack Daniels. Did about a splash and a half of Coke. It's like 1 beer, an ounce and a half of whatever. And it's like, why are you telling them this?
It's amazing some of the things that you've come across, and we've all come across in these police reports, is that, the story you get from the person who's in this situation is one thing, and then you read the police report and it's completely, you're like, am I reading the same report? Am I in the same situation? Because it very rarely matches up.
I think people get nervous when they get pulled over by the police. It's understandable. And they're just kind of like vomiting information, because that's just a nervous trait that people have, to just keep talking, or they're going to talk themselves out of it. You know what? I'm going to tell this guy I had 2, but I'm fine. And it's like, that doesn't work. So it's just no, simply no. You can decline answering questions and still be respectful.
Right, and that's the whole thing. I think most people want to be cooperative. Most law-abiding citizens do want to be cooperative with the police, and at some point they're too cooperative. Cooperative to a fault, where they're actually digging their hole a little bit deeper in the situation. I think that's what you're referring to, is that they're,
right,
and maybe nervous. Yeah.
Just keep in mind that when they ask you that question, you give them an answer, you're putting another nail in your coffin. You're giving them something in the courtroom they're going to use and say, well, he admitted he drank, so that's his own admission. And they're using that with all their other observations. All a police officer's doing when they pull you over is collecting information to create probable cause. So it's like, the driving is one. Was there a car accident? Was there bad driving? What are the observations I made? What admissions did this person make when I pulled them over? Then they're collecting all these pieces of information and charging you with a DUI, and then they get used against you in court.
And as a prosecutor, as a former prosecutor, one of the things that what you like to see as a prosecutor are admissions from people when they're in the presence of the police, because those admissions can be used against you and in court. And very well as I do, they will be used against you, because that's some of the best evidence that they have, especially if there's later you decline to take a breathalyzer. The best evidence that they may have is going to be their own observations and your own admissions about what you were doing that night.
Right, where you were going, where you coming from. I mean, yeah, I'm coming. It's 1 o'clock in the morning. I'm coming from the bar. Did you drink? I had 3 drinks, but I'm fine. It's like that generally doesn't play out well in a police report.
Right. And then so you're at this point now, you've had this interaction with the officers. And one of the other questions that we tend to get is, what do I have to get out of the car? And do I have to take those roadside field sobriety tests? Now, where do you come on that, Lauren?
I mean, you're going to have to get out of the car. If a police officer asks you to get out of the car, you're going to have to get out of the car. Odds are that once you step out of that car, you're already going to get arrested. If they're asking you to get out of the car, it's because they're making observations that are probably enough to at least get them to the probable cause point of arresting you. So when you get out of the car, they're going to be looking at how you get out of the car. Are you holding onto the side of the car for balance? Are you stumbling when you walk? So you do have to get out of the car if they ask you to. You do not have to submit to the standard field sobriety test. And people seem to think that the standard field sobriety tests are like the end all be all for determination of a DUI. Like, oh, well, I failed those. So they're really, again, just another tool that the police have to make their case of a DUI against you. So you can decline those tests, and those tests really are designed to show indications of impairment of over a 0.08. All 3 tests. One of them is not admissible in court, which is the horizontal gaze nystagmus, which is the pen that they move and they track the resting nystagmus in your eyes to see if sort of as your eye travels and follows the pen, if you're over 0.08, your pupil in your eyeball will just bounce a little bit. So that's generally not admissible in most courts in Rhode Island. But again, it's something that can be used against you in court, just in the negotiation phase, the pretrial phase. Well, they failed these 3 tests. The other 2 tests are the one leg stand and the walk and turn. So they're looking at how you perform those tests. They're looking at, can you follow instructions? Did you take the right number of steps? Were you paying attention when I showed you what kind of turn to make? And then those tests really don't apply to people if they're over a certain age, if they're overweight, if you've got any type of injury, like a knee injury or hip injury, back injury, something that would prevent you from performing those tests just regularly. So you can definitely decline those, and I would suggest declining them because they're just using what they observe of you during those tests as evidence against you. Even if it's not the actual test that they're using, they're standing in front of you doing this pen test with you, and they're looking right in your eyes. They're smelling your breath to see if there's an odor of alcohol on it. It's just another opportunity for them to, create evidence and create a case against you.
Right. And these things are what we refer to as divided attention tests. They're seeing if you can multitask. It's just more than just the physical performance that they're looking at, whether or not you can maintain your balance on one leg or walk in a straight line. It's whether or not you can, like you said, follow directions, talk at the same time, and perform the physical tests in a way which they believe a sober person could do. Now, Lauren, do you think that a sober person would be able to perform most of these tests and pass, given the way that they're uniformly, or I should say, not uniformly performed by the police departments who are pulling you over?
I think it depends. I've tried the tests in heels, like in my work shoes, and I can't do them. So I think it depends on what kind of footwear you have on, what the surface is like. If you can't see the surface, I think it makes it more difficult at night if it's not well lit. And they are supposed to make sure you're on a flat area that's well lit, that's free of debris, so that you can have your best chance at performing these tests. But they're not easy.
No, they're definitely not easy, and it's very rare that I ever saw, as a prosecutor, that I ever saw a report that says the subject passed the standardized field sobriety tests. There's usually something they find that you did wrong on those situations. But a lot of people didn't know that you can refuse to take those field sobriety tests, and it's not like declining the breathalyzer. There is no penalties for not taking the standardized field sobriety test. It's your right not to do it. Now, if you don't take those standardized field sobriety tests, are you going to get out of the arrest?
No, I mean, I think if you're out of the car, it's a pretty good chance that you're getting arrested anyway. I mean, I've never seen a police report where someone has gotten to the point where they're out of the car and taken those tests, and the officer's like, "Well, that cleared everything up. You're free to go." I mean, I've just never seen it happen like that.
Nor have I. Nor have I. As much as I'd like to see it happen now that we're on this side of the aisle, unfortunately, it doesn't happen all that often. If I can remember one instance, I don't think I can, but it's a situation now where you're probably going to be under arrest, one way or the other, whether you failed the standardized field sobriety tests or you decline to take it. You're probably going to find yourself under arrest, and now we come down to that age-old question, which everybody likes to ask, is that do I have to take that breathalyzer test? It's good that they're going to ask me eventually, do I have to take it?
Well, I just want
What
to
do you
back
think?
up to the field sobriety test, because there are actually some cases where you may run through those tests. So they might not smell alcohol, but they may see that your driving's kind of erratic, that you're distracted, your eyes, your pupils look weird, or they're bloodshot and watery. You kind of have a delayed response. They might think you're under the influence of a narcotic or some type of drug rather than alcohol. So you could actually go through those field sobriety tests, pass them, and still get arrested. So that's why I say that once you're out of the car, chances are you're getting arrested anyway. So why would you give the police any more evidence to incriminate yourself if you don't have to?
Exactly. And actually leads you to a good point, because, as we know, and many people don't know, it's illegal to drive under the influence of either alcohol or any controlled substance. Whether you're under the active influence, you have to be under the active influence of that. Are those field
Even
sobriety
marijuana.
tests? Yeah, even marijuana. And even though there's a certain amount of marijuana that is not a criminal offense to possess in Rhode Island at this point, even if you have a card that allows you to possess and use marijuana, a medical marijuana card, if you're under the active influence of it, you can still catch a DUI if they believe that you can't operate your motor vehicle in a safe manner. Isn't that right?
That's correct. So you could have your marijuana card, you could be able to smoke marijuana, take whatever you're doing with your marijuana, have that card from a doctor, but you could still get pulled over if if an officer, like Chaz had mentioned, believes that you're unsafe to operate that motor vehicle under the influence of that marijuana, and they if they draw blood, then they're going to be able to see whether the THC is either active or inactive. If it's active, you're driving under the influence. A lot of times people won't consent to blood draw, but we can talk about that after we talk about the breathalyzer, if you'd like.
Well, they get the breathalyzer test is usually the most common one that people are going to come in
Yeah.
contact with, right? Yeah. So
Right.
everybody wants to know. Everybody wants to know: should I take that breathalyzer test if I'm asked to take one, if I'm under arrest for driving under the influence? What do you go take into account when you advise clients or anybody who asks you really on that question?
I mean, I would say not to, unless you really truly are not under the influence of alcohol, or you're under the influence of alcohol, but you think that it's below a 0.08. But it's hard to know that about yourself, how many drinks it's going to take to get you to over a 0.08. For someone like me, it might be one or two drinks. For somebody else, it might be four drinks. It all depends on, there are a lot of factors: your tolerance, what you had to eat that day, your body weight. So it's very difficult for someone to be able to say, well, I think I probably am good, or I'm, just over a 0.08, or I'm just under a 0.08. But unless you're actually not under the influence of alcohol, I probably would not advise someone to take that test.
Right, and it's like playing a game of Russian roulette over there. If you're gonna, if you actually have been drinking in any way, shape, or form, deciding, oh, let me kind of roll the dice here and decide whether or not I'm going to be over that 0.08, that magic number 0.08, which is the it's a rebuttable presumption, but it's a presumption that you are under the influence of alcohol if you get that blood alcohol content reading. So you're basically playing Russian roulette, because if that reading comes into evidence, basically the state's case is pretty much made at that point. Am I right?
Right, because now really the elements that the state needs to prove a DUI are that you were operating a motor vehicle, so they need operation of you operating a motor vehicle, whether they get that directly or circumstantially, and then they need to prove you're under the influence, and they can do that one of two ways. They can either do that with blood alcohol content, which would be the results from the intoxilizer, or they can do that from a police officer's observations. That you're under the influence to a degree that renders you incapable of safely operating a motor vehicle.
So that means essentially that even if you refuse to take a breathalyzer at that point, the police can still go forward on the DUI charge. They just have to use their observations and their experience and training to talk to the jury or the judge in whatever case it may be, to tell them why they believe that you are under the influence of alcohol and why you cannot actually operate that motor vehicle safely to a degree that, renders you incapable of operating that vehicle safely. Am I right?
Yes. And, really for someone who's like a first time offender, someone who's never been in trouble before, when you refuse, you get charged separately with a civil violation, which is a refusal to submit to a chemical test. It's a totally separate case, and generally, if it's a first offense, in a separate courthouse with a different, burden of proof, different elements. So you end up with an opportunity, depending on the circumstances, and all cases are different, but generally you end up with an opportunity to resolve the civil violation in exchange for a dismissal of the criminal violation. And that, as a client, puts you in a better position, at least gives you more options than it would be just to have the DUI with the readings.
So yeah, and I want to go into that because that's been the standard practice in Rhode Island for as long as at least I've been practicing, and I know just from talking for people who've been practicing a lot longer than I have, it's been going on a lot longer than that. So the benefits obviously of avoiding a DUI conviction is you avoid a criminal conviction, you avoid that having a criminal record. Getting a breathalyzer refusal, although it's civil, you're going to lose your license for a period of time. You don't get a criminal conviction out of that. And generally, if you're a first-time offender, no aggravating circumstances like an accident, injuries to other people, fighting with the police, something along those lines, people have been getting the opportunity to resolve their matters in the civil context and the breathalyzer refusal up until recently. And we've come to learn our favorite Attorney General, Peter Nerona, has decided that he's going to change that practice going forward. Did you hear that same rumor, Lauren?
I did. I've heard some rumblings about it. So it was always when I worked for AG Kilmartin, it was always, and when I interned, prior to that, it was always kind of the general practice. I mean, and I hate to say general practice because it really shouldn't be considered like that. It's every defendant is different and every fact pattern is different. So as a prosecutor, you need to look at the person and the circumstances. So the person, their mitigating circumstances, who they are, what they do, what their record is, and then also the facts in the police report. So generally, so you've got someone who, let's say I've got a client and this is a made up person, this isn't anyone real. So say I have a client who's a teacher. She goes out for drinks with her friends. She has a couple glasses of wine. She gets pulled over coming home, at 11 o'clock at night, swerving over the lane a couple times. They pull her over. They make observations. She does the field sobriety test. She refuses to submit to a chemical test. Now I'm in a position where I can talk to whoever the prosecuting agency is, whether it's a town, whether it's the state police through the attorney general, and see if they'd be willing to dismiss that DUI in consideration for the refusal plea, the civil violation over at the traffic tribunal. And that just puts my client in a better place because she's taking the fines are going to be a little higher. The license loss is going to be a little bit longer, but she's also not going to have a criminal conviction on a record that she might not be able to get expunged for 5 years. And there are some judges that are not expunging those for 10 years because the new ignition interlock statute 3127 2.8 allows a look back for purposes of the ignition interlock for 10 years. So some judges do interpret that as I'm not expunging any DUIs for 10 years. So
The
now you
fact
have
that you could
someone
just
who
roll
has
that
no
statute off your
contact.
the fact that you could just roll that statute right off the tip of your tongue is impressive, because I would not have been able to do that. But keep going. That was great.
So, you've got a client now who has a job, who has no criminal record, who's like, an upstanding member of society who just had a bad night. And, I think anyone can relate to that. I think you're an animal if you can't relate to that. I mean, no one's been hurt. Yeah, drunk driving is very serious, and I prosecuted these cases, and I've seen the worst of the worst. I've went to the prison to listen to Mothers Against Drunk Driving talk about how a drunk driver killed their child or extremely disabled their child. So it's like it can be it can be horrible. I mean, people can die. It's absolutely not something anyone should be doing, but people make mistakes. And, should those people have a criminal record for 10 years? I don't think so. So.
Right. And I guess the bottom line here is that nobody's endorsing drunk driving. Nobody thinks that's a good thing. And just because we defend people who come across, are being charged with these things, doesn't mean that we are, encouraging them to do it, or trying to give them a way to get out of it. We're trying to make the situation as painless as possible for people who, like you said, had a bad night, had a one-time situation where just things didn't go their way. And it's bottom line is, you're going to be in a world of financial hurt and probably a world of mental anguish if you have to go through the situation. And it's important to have people who know what they're doing, who can walk you through these very complex steps, and they can be very complex, going between the traffic court, either the district court, traffic court, even the DMV. You got to walk yourself through the process of getting potentially hardship licenses, potentially having an ignition interlock installed in your car, and then finally complying with all the requirements to get your license fully reinstated by the DMV. They're all separate processes. That's a situation which a lot of people find overwhelming.
And that's what I tell. Usually I start clients off by telling them I'm going to get a copy of the police report, I'm going to review it, and I'm going to make sure that all the proper rights were read, that police followed the proper procedure, that the state can meet all of the elements within the statute, even though there really only are 2 elements. There's all little subsections of things they need to do. For example, if you do submit to the chemical test, they do need to mail those breath results to you within 72 hours. So just checking those little things to make sure that everything was done properly, and then having a conversation about how to resolve it in a way that's most favorable to our clients. But there is a lot of work involved, and you need someone who knows what to look for.
Right, and you have to know your audience, and these cases are treated differently, unfortunately, depending on where they happen. You're going to have cases, maybe perhaps in Kent County, they're going to be treated differently than they are in Washington County or Providence County. You may not get too many of them, but you may get a lot more of them in Newport County. And you got to know which judge is going to hear it, or whether or not it's going to be before the district, the traffic court. And you got to know what those judges are looking for and what they are going to expect out of you as a defense attorney and a prosecutor, because that can make or break your case. Would you agree with that?
Right. You need someone who's well versed in this type of area of law, in criminal law, who knows, Chaz and I are in court pretty much every day, in every court. So, you need someone who understands the ins and outs of that, as well as just how to handle a DUI.
So I know we touched on it a little bit. So what do you think of this upcoming change in policy coming from the Attorney General's office, where they are going to push for the result, push for the conviction on the DUI, even on first-time offenders, as opposed to considering allowing them resolving their cases on the civil breathalyzer refusals?
I mean, I have a problem with anyone having a policy in that office. So like, it's our policy to do X, Y, and Z should never come out of a prosecutor's mouth. At least I don't think it should. It should be that I trust my lawyers that work for me. If they're not capable of handling something, then they shouldn't work there. And, if you have someone who understands, like, for example, DUIs. They know how to prosecute them. They should be able to make a determination about how well they think their case is, but also you need to take into account, like I mentioned, every person's different and every fact pattern's different, and you have to take that into consideration. So I have a problem with any like office-wide policies like that, because I just don't think it should operate like that.
Right. You can hire anybody to stand there and just say the same thing for, DUI, we're going to
Right,
offer
just get a
this.
bunch of robots
DUI,
and
we're
get
going to
them a
offer that.
script and say, you know what, if it's a lane roadway violation, we're going to do this. If they hit a tree, we're going to do this. If there's a 2-car accident, we're going to do that. And you just have a script and you just have robots working for you, I guess.
How much legal training does that take to have somebody do that for you?
What, to just write a script?
Or to read the script? How much legal training do you? I must have missed that class in law school.
I think I did too.
So, I mean, we're joking about that, but unfortunately, it has real life consequences when you have someone who has the authority that the Attorney General's office has to have a blanket office-wide policy that does not take into consideration individual facts and circumstances which go into each one of these cases, as Lauren was talking about. It affects people in a very serious way, particularly saddling somebody with a criminal conviction for a DUI, which in many cases won't come off their record for at least 10 years. So, I agree that when you have these policies that the prosecutors are acting in a way which is inconsistent with the pursuit of justice, which should be the mission of a prosecutor's office.
And you have these things in place now. Like when I was prosecuting refusals at the traffic tribunal, it was prior to that interlock statute. So I think that was November of 2014 when that interlock came into play in the traffic tribunal. So prior to that, you just had a minimum 6-month, like on a first offense chemical test refusal, you had a 6-month loss of license, and the range was minimum 6 months, maximum 12 months on a refusal. So you have people coming in and they're taking a huge hit. These are people who have jobs, who need to go to work, who have families, they need to drive their kids to school, and they can't operate a motor vehicle for 6 months. That's a heavy penalty for someone who has no other criminal record, and this is a first-time offense, and there's no extenuating circumstances. So there's not a car accident where someone was injured. There's not a leaving the scene of an accident or anything like that. I'm just talking about a regular DUI refusal. So, now we have this ignition interlock, which what someone would do is, as part of their plea, is they would install an instrument in their vehicle. It's professionally installed, costs about $100 a month to have, $100 to get installed, about $100 a month to maintain, and about $100 to take out. A lot of these places do have specials where they'll give you like a month free or something like that. But you're putting this in your car every 15 minutes. It beeps, you blow into it. In order to start your car, you need to register no alcohol content. So if you're drinking the night before and you're still intoxicated in the morning, your car won't start. So we have ways to make sure that these people are safe putting them back on the road after a DUI. So it's not necessary, I don't think, to really hamper someone with a criminal conviction on their record for the next 5 to 10 years on a first offense with no extenuating circumstances.
Especially since the goal here is to make sure people are operating their vehicles safely. And, Pat and I were talking about it last week that, I can't think of very many more jarring things when I'm driving down the highway and I have a machine beeping at me to blow into the machine. I'm driving 65, 70 miles an hour, perhaps, down the highway, and all of a sudden I got to pull over because I got to go blow into this machine. Is that more or less dangerous than, having a couple glasses of wine at dinner and then driving? I don't know, but I certainly don't think it's an ideal situation. But at the same time, we are not, we're trying to make sure people are driving without being under the influence of some sort of alcohol or controlled substance. We have these tools at our disposal, and they're tools that unfortunately now are being watered down, whether it be by the Attorney General, whether it be by judges at the traffic court or the district court, with limiting the hardship the hardship times where you can operate your vehicle. These are things that everybody has to consider when you're looking at how we're going to resolve your DUI or breathalyzer refusal case.
Right. And, when that statute was enacted, it was designed to make sure people don't lose their jobs. So having someone come into the traffic tribunal, if you have a refusal, the important thing to understand about that is once you're arraigned at the traffic tribunal, which is generally about a week to 2 weeks after you've been arrested, is that they're going to preliminarily suspend your license 9 times out of 10, unless there's something glaringly wrong with the affidavit or the report. So they're going to suspend your license. So this ignition interlock was designed so that people wouldn't lose their jobs while their DUI cases were pending, while they were under a 6-month minimum license suspension for a refusal. So, and then that's exactly why the hardship statute or provision of that statute was created as well, was just to make sure people could still get back and forth to and from work. And when we talk about that hardship provision, what we're referring to is in the ignition interlock statute, there is a provision that allows, so the minimum period of license loss for a DUI would, with the ignition interlock, would be a 30-day loss of license. So you just completely can't drive for 30 days, followed by a 3-month ignition interlock period. So for that 30 days, the hardship, if you qualified for that and the judge felt that it was warranted, could grant you a provision which allowed you just to operate to and from work with the ignition interlock in your car for those first 30 days. So that you're not having to get rides to work. Maybe where you live isn't on a bus line. It's not feasible to take public transportation. So it's really designed to make sure people don't lose their jobs.
Right. And especially in this society where we've had a lot of people being financially hurt by the effects of the coronavirus. This is a time where people have been cooped up in their homes. They've lost their jobs. They've done things already, and now society's starting to get back to normal, although it's not quite back to normal yet. But they're starting to get back to normal, and these are tools that we as defense attorneys are hoping that we can use to help our clients keep themselves above water, keep their jobs, keep their houses in some cases. That's an extreme case, but these are situations what we're trying to get. And to have a blanket policy where this is not going to be available to the people, first-time offenders, again, no other extenuating circumstances, is really going against what we as society and the General Assembly in recent enactions of laws are trying to do, get people back on their feet. Would you agree with that?
Right. And that's the problem with a policy like that, is you're just saying that you're not going to consider any set of facts. You're not going to consider any specific defendant. It's just a blanket response. Like, we are not allowing people to plead to a refusal when we think we can prove a DUI.
I actually heard a prosecutor the other day say, oh, it's this type of case. This is what we offer on all those cases. We treat everybody the same. Would you, when you were a prosecutor, was that what your approach was?
Never, never. No, I had a really good boss. I had a lot of the chief of the criminal division when I was there. Allowed us to pretty much make our own decisions, at least me. I can only attest to myself, but it was like, if this is what something was, it's what it was. And that's what, there was no make sure this happens, or make sure if this set of facts exists that you make sure you do that. So there wasn't as much micromanaging.
Right, and a lot of people give Attorney General Kilmartin a lot of grief for a lot of different reasons. Some of it genuine, some of it is just political sniping. But that administration, you can say what you want about him. He had a lot of good people working for him, including you and I, and some of the people who were in charge of that. It's a little different under this current administration because Peter Nerone is the former U.S. attorney appointed by President Obama. So he should know better, in my opinion, that you don't treat every single case that comes before you with the same charge the same way, regardless of who is in front of you as a defendant. And that's, as you may know, I'm running for attorney general, and one of the areas I take a lot of umbrage with what the current attorney general is doing is these blanket policies and these top-down directives that are coming in, which go against the pursuit for justice, which every prosecutor ought to be pursuing. Would you agree that that has become more of a problem?
I mean, I can't think of one time in the course of my time there that Stacy Veroni, who was the chief of the criminal division, came into my office and told me that I needed to resolve a case a certain way. Not once. So it's just not how things were run when Attorney General Kilmartin was in office. But no, I think that it's a huge problem. It's a huge problem for his staff, and it's a problem for defense attorneys because it leaves us nothing to work with. I mean, you've got your client and you know about your client and you want to tell the prosecutor about what the mitigating circumstances are. And, you know, you're not always trying to get a case dismissed because sometimes when you read the report, you're like, you know what, this report's buttoned up. I know certain police officers in Providence, like if I get a Providence police DUI with Officer Troy, who I think is sergeant now, I know that DUI is going to be so buttoned up that there's going to be no wiggle room for me to do anything with it. So, you know, at that point, it's just, well, I think as, you know, someone who's very experienced with these cases, that I think that the state can prove what they need to prove for a DUI or whatever town or city it is. At this point now it's, you know, can my client pleaded the refusal and have the DUI dismissed because there was no accident. There is no other prior criminal record. They have a job. They have an education. They have a family. You know, these are all the things that we're bringing up to a prosecutor that we want them to take into consideration.
And if they're not looking at it from an individual perspective, then these things are meaning less and less to them, and it gives us less tools to work with.
Right. It just puts people as, you know, as like everyone's a criminal. And just in this, especially with the DUI, it's like I've seen real estate agents get DUIs, doctors, lawyers, I mean, all walks of earth, like 60-year-old men, 19-year-old kids. I mean, people who aren't even old enough to drink. It's like it affects all walks of life. And you have to, you know, you have to have someone who will look at the person in addition to the case and make a determination rather than just say, nah, we're not doing that on these cases anymore. That's not really the response that that is helpful for the people of the state of Rhode Island.
And you know, I've said it a bunch of times that, you know, you have our attorney general who's been on TV many times over these last 2.5 years talking about how he's going to be the kinder, gentler office. They're not going to incarcerate people for drug charges. They're not going to incarcerate people for nonviolent offenses. But you have someone who's giving top-down policies, top-down directives to their prosecutors who are not
None of my drug cases are getting dismissed. I can tell you that. None of my clients with drug cases are getting dismissed, so or amended.
It's not happening. So you know, what Peter Neronha has been telling everybody on TV is exactly the opposite of what's being done in court. And I don't know if that's coming from him or if it's coming from his new chief of the criminal division. But it's, you know, when Peter Neronha goes on Gene Valicenti and tells everybody that he's not doing these things, it's simply not true. Would you agree with that experience?
I mean, I remember coming out of the gate, like, you know, having drug cases in, you know, possession of a Schedule 1 through 5, which some people refer to as a simple possession case. So it's just, you know, someone gets arrested and they have whatever narcotic, whatever Schedule 1 through 5 narcotic on their person. It's not enough to be an ounce to a kilogram. So it's in that specific category, that area. And, you know, he made this big pitch about how those should be misdemeanors. And then when you go to court as a defense attorney with a client who's been charged with that, it's like, well, why aren't you amending it to a misdemeanor if your boss thinks that all these cases should be misdemeanors? Or at least that's what he's saying. In a political forum, like, why are we not, it's not being practiced. And I think, right, you know, that's a good example of exactly what you're talking about. You got to practice what you preach.
Absolutely, we practice what we preach, and we're always out there looking for the pursuit of justice. We've
Right.
certainly we've certainly covered a lot of information tonight. Hopefully, it will be helpful to somebody out there who's watching that. And Lauren, I want to give you a minute or so to shamelessly plug yourself and where people can find you and where they can have your services. So, like Pat has done for me, go ahead and give yourself a
Right.
shameless plug.
All right, here's my shameless plug. You can find me located at Inman and Torgy with Chaz. We're at 1500 New Snack Hill Road in Coventry. If you're not from the Coventry area, don't worry about it. We practice all over the state of Rhode Island. So we're in all of the courthouses, in the traffic tribunal. I take cases from Woonsocket to Westerly. It really doesn't matter where you are. If you don't want to drive to Coventry, we can meet you somewhere else. We can certainly accommodate a FaceTime or a Zoom meeting, but this is definitely something that I would not try and navigate the waters yourself. You need an experienced DUI attorney who understands the law and make sure that the police are doing what they're supposed to be doing when they pull you over and following the protocols and that the law is followed. And if they're not, we're going to be the first person to point it out and tell you you've got a shot and you should take this to trial, or we're going to negotiate this in a way that benefits you the best. So you can find Chaz and I both at the same law office. We can be found on Facebook, and our website is it itwlaw.com.
That's it, itwlaw.com.
Yep.
Where Inman and Torgy is lucky that they have two very experienced criminal defense attorneys who not only practice in criminal defense, but we practice in various different areas: family law, personal injury, several different areas of civil litigation. Inman and Torgy is a full service law firm. You get the big city experience and the small town feel. So you got Lauren and I here both working for you in those situations. And I really appreciate you coming on tonight, Lauren, and helping walking us through the DUI experience that unfortunately a lot of people go through. And I think that ends our show tonight, but I'm hoping that Lauren will join us again and we'll have some other guests on. Chaz Calenda, attorney at law. We're going to hopefully have this series continuing to go and tackle some of the more challenging legal issues that you see, and eventually talk about my run to be the next Rhode Island Attorney General. And we'll get some opinions and thoughts on that going on. I appreciate you all joining me. I appreciate Pat Ford giving me this opportunity to address all of you. And I look forward to seeing you on the next episode of Chaz Calenda, Attorney at Law. Have a good night.